So in the second panel of this afternoon, we start with Professor Gary Jacobsohn, who holds the chair on constitutional and comparative law at the University of Texas at Austin. And he specializes on constitutional theory, mainly in the intersection of constitutional theory and comparative constitutionalism. Among his many publications, I guess the one that needs to be remarked today is the article on An Unconstitutional Constitution, a Comparative Perspective, which is the main issue of our discussion. So it's a pleasure to welcome you, Professor Jacobsohn, to speak about India and its jurisprudence. Please.
So in part, I'll be talking about matters of internal coherence. Having arrived from Texas last night, whether I'll be able to demonstrate such coherence remains to be seen. It's nice to be here, however. I was here in this very room 10 years ago speaking about the constitutional revolution of Israel, which mainly dealt, of course, with the question of just ordinary judicial review, which, given this topic today, seems, in retrospect, to be a very simple matter. We've come a long way. There are lots of angles to the unconstitutional amendment story, and my comments are going to focus on two that are concerned with issues of maintenance. One having to do with the preservation of constitutional identity, the other with the defense of institutional prerogatives. Now, I may also be the only political scientist in this. I don't have a law degree, and I noticed that nobody has yet spoken about institutional maintenance. That is to say, the defense by the court of its prerogatives, which explains a good deal of its assuming this extraordinary power in some situations. Now, the American constitutional experience from which I come has very little to say to this topic. It has not contributed much at all to our understanding of the question. Nevertheless, I want to begin with Abraham Lincoln, who said in his first inaugural, quote, "This country belongs to the people who inhabit it. Whenever they should grow weary of the existing government, they can exercise their constitutional right of amending it or their revolutionary right to dismember or overthrow it." As we will see, a key question is whether the power to amend, in fact, comprehends the power to destroy. At least in the United States now, the question of the power to tax being the power to destroy is what everybody is talking about. Ultimately, the position taken in India was that it does not. So this is where I turn now. I guess my job here is to talk about that mischief maker that has been alluded to by various speakers to this point. India's is not one of those constitutions empowering courts with review of constitutional amendments on substantive grounds, even procedural grounds. Also, it's not a constitution with particular matters that are specified in the document as unamendable. Yet, as we all know, it has gone further than any other court in the world, and it has done so in the absence of any kind of express constitutional authorization. Moreover, in other ways, the Indian example is not an obvious case. The provision for amending the document was shaped explicitly, if you read the Constituent Assembly debates, to conform with the Jeffersonian idea that each generation should be free to adapt the Constitution to the conditions of its time. And in fact, the experience follows very much from that original expectation. Some 80 amendments in 50 years have been added to the Indian document. Add to this effusive embrace of change the rootedness of Indian legal culture in the British legal tradition, and it's natural to suppose, in fact, a hostile Indian reception to the notion of implied constitutional limits. Thus, it's not surprising to have a judge declare, as one did in India, the power of amendment is in point of quality an adjunct of sovereignty. If so, it does not admit of any limitations. This was the early view expressed in India, and it is quite compatible with what I imagine to have been the original expectation of most of the Constitution makers. Now, those who argue for implicit limits on the power of amendment often invoke the theory of popular sovereignty. Those who oppose them just as often find the theory sufficiently supple to provide justification for their counter-arguments. But the argument from democracy, I would argue, only gets you so far. In the end, the issue of amendability, specifically the limits on amendability, turns largely on the question of identity. And on this we can learn a great deal from the South Asian experience, but it is not by any means a straightforward, unambiguous lesson. The Indian history with the amendment problem, of course, presents a very compelling narrative. Indeed, there are at least two stories one can tell. The first concerns a decades-long political give and take over the place of private property in India. The second features a protracted struggle by the Supreme Court to establish its credibility and independence in the face of repeated attempts to diminish its standing as a significant force in Indian politics. These stories are tightly entwined and are distinguishable only by the theme one chooses to emphasize. But in both accounts, they are dominated by the looming presence of one Indira Gandhi. So I want to just briefly now touch upon a few key cases. Some of them have been mentioned earlier. And then turn actually to India's neighbor, Sri Lanka, which at least in jurisprudence is not so easily swayed by its powerful neighbor. So very quickly, the cases. The first one is the landmark Golaknath case of 1967, where the court determined that there is no power in the legislature to pass an amendment abridging fundamental rights. In this case, the right in question was private property. It was an assertion by the court of its role as protector and preserver of the Constitution. Until this decision, the Parliament was viewed as exercising sovereign constituent power. Now, the government, in arguing the case before the court, said the following, quote, "Short of total repeal of the Constitution, any form of government with no freedom to the citizen can be set up by Parliament by exercising its powers under Article 368. This was probably not a very intelligent rhetorical strategy. And in response, the main opinion by the Chief Justice of the Indian Court introduces us to the critical question of what the word amend actually means. His preference for a limited understanding must be seen in connection with his main point, which was that fundamental rights are given a transcendental position under our Constitution and are kept beyond the reach of Parliament. Thus, Parliament cannot exercise constituent power in the true sense. Now, you'll notice there is an invocation of a kind of natural rights theory. I want to quickly say, however, that this flirtation with natural rights was very short-lived, and it doesn't persist even through the next more important cases, the next one of which, of course, is the most important, the 73 case of Kesavananda, which has been called by the most distinguished Indian constitutional scholar the greatest contribution of the Republic of India to constitutional jurisprudence. In essence, just to summarize, the court, or at least 7 of its 13 participating judges, affirmed the authority of Parliament to amend constitutional provisions involving fundamental rights, while rejecting its authority to place statutes enacted to implement the Constitution's directive principles beyond the power of judicial review. In other words, it reversed Golaknath, but narrowly asserted the authority to invalidate a constitutional amendment that was in defiance of the basic structure of the Indian Constitution. The dissent in this case, and it was a vigorous one, argued that no distinction could be made between essential and non-essential features. Indian jurisprudence had, however, become quite familiar with the distinction between essential and non-essential. One of the reasons I think that the doctrine was embraced in India in particular was through many years and agonizing jurisprudential encounters with the religion question. The court was required to determine what is essential to religion and what is not essential to religion. A determination which, given the significance of religion in terms of the daily lives of people, could not be casually set aside, as it is in the United States, for example, where judges believe that the centrality, what is central to a religion, is of absolutely no importance to judges. Two intertwined theories entered into Kesavananda: the basic structure doctrine and the idea of implied limitations. Partly it was a kind of a Marbury exercise, syllogistically put in this familiar way. All legislative power is subject to inherent and implied limitation. Second, the constituent power in Article 368 is a legislative power. Therefore, the constituent power is subject to inherent and implied limitations. Not only does it follow the logic of Marbury, the result is very Marbury-like. The amendments in this case were upheld, while, however, strengthening the court's power of judicial review. The main author in this judgment, Justice Khanna, wrote, and I quote, "The word amendment," and we've heard intimations of this earlier in Justice Barak's remarks, for example. "The word amendment postulates that the old Constitution survives without loss of its identity, despite the change, and continues even though it has been subjected to alterations." In other words, amending does not incorporate altering or destroying constitutional fundamentals. This, it should be said, was not enthusiastically embraced at the time, but we can thank Indira Gandhi for diminishing the resistance to it. And that brings me to the famous case involving the Prime Minister herself, who got herself ensnared in some rather corrupt dealings that brought her back to the seat of power. And then she saw fit to have passed the 39th Amendment, which, it just so happens, prevented any judicial inquiry into the election of the Prime Minister. To save a single individual, in other words, the Constitution was amended. And as one noted legal scholar said, nowhere in the history of mankind has the power to amend a Constitution thus been used. Another, the 38th, passed at the same time, shielded from judicial review any laws adopted during the emergency that might conceivably impinge upon fundamental rights. Gandhi's claim here was Schmittian in the extreme. In essence, the constituent power, as an expression of the sovereign will of the people, was all-embracing and at once judicial, executive, and legislative. It was such an extravagant claim that it accomplished what all previous debate over these property-related amendments had not succeeded in doing. Namely, it established the legitimacy of the unconstitutional constitutional amendment. This was affirmed in the final case, just very quickly to mention, in 1980, the Minerva Mills case, in which it was determined that judicial review itself is an unamendable basic structure. Parts of yet another amendment, the 42nd, were also invalidated as a ringing affirmation of the basic structure doctrine. This amendment represented Mrs. Gandhi's last strike at the court, including the provocative declaration, quote, in the amendment, "No amendment shall be called into question in any court on any ground." That is to say, no limitation on the constituent power of Parliament to amend the provisions of the Constitution, leading one of the judges to write, "Amend as you may even the solemn document which the Founding Fathers have committed to your care, for you know best the needs of your generation. But the Constitution is a precious heritage. Therefore, you cannot destroy its identity." One of the last holdouts on this whole idea, Justice Bhagwati, who had resisted this idea for many years, finally had to come around. He said, if by constitutional amendment Parliament were granted unlimited power of amendment, it would cease to be an authority under the Constitution, but would become supreme over it, because it would have power to alter the entire Constitution, including its basic structure, and even to put an end to it by totally changing its identity. Now, interestingly, as many of you know, it was the German experience that offered the Indian judges guidance in their extended parrying with Indira Gandhi. She, of course, had a lot to learn from it as well, if, alas, from an earlier decade. Ironically, both the judges and the Prime Minister could find in the person of Carl Schmitt a source of ideas for their conflicting agendas. For Schmitt, as we know, is at once the guru of emergency power and the proponent of the notion that there are fundamental principles which limit the amending power. And of course, in Germany, though they haven't exercised that power, by 1967, the conceptual possibility of so exercising it was embraced in German jurisprudence. A constitutional amendment could be subject to nullification to the extent that it was responsible for transforming the document to which it was added into something fundamentally incoherent, this being the German post-war view. Now, of the several reasons adduced by the Indian Supreme Court in analyzing the unconstitutional amendment, the one that stands out is a version of the incoherence argument, which is to say the need to preserve constitutional identity. Now let me turn quickly to Sri Lanka. There's a point that can too easily be overlooked after reflecting on this Indian experience. Substantially amending a constitution need not threaten the existence of constitutional government. Moreover, when it seeks to bring about change that expands rather than truncates the rights of large numbers of people, it may inspire a more skeptical attitude about a preservative role for the court in defending a nation's specific constitutional identity. Imagine, for example, a court sympathetic to the objection that the 13th and 14th Amendments to the United States Constitution so radically transformed the relationship between the states and the federal government to the disadvantage of the former that they threatened the existence of a basic structure of constitutional design. Would judicial intervention in defense of constitutional identity, the precious heritage under assault from forces within the polity, be justified? Now, in 1987, the Supreme Court of Sri Lanka directly confronted an amendment's challenge to constitutional identity in a case described by its Chief Justice as the most critical, the most important, the most far-reaching case that had ever arisen in the history of our court. It concerned, wouldn't you know, the constitutionality of the 13th Amendment, its 13th Amendment. Like its American counterpart number, it was challenged for its alleged radical restructuring of constitutional arrangements, namely the balance between central and local authority. Relatedly, it was challenged for its alleged attempt to deny the preeminent position of Buddhism in the Constitution. But unlike in the United States, the proposed change in Sri Lanka involved a devolution of power to the local level, even if the purpose was comparable to what lay behind the American amendment, namely the enhancement of power and prospects of a much abused minority. The minority in Sri Lanka, of course, being the Tamil minority. And by the way, just parenthetically, since we're talking about 13th Amendments, the original American 13th Amendment, otherwise known as the Corwin Amendment, would indeed have presented the American court with an unavoidable instance where this question of the unconstitutional constitutional amendment, it seems to me, could not have been avoided. The original text of the 13th Amendment reads, "No amendment shall be made to the Constitution which will authorize or give to Congress the power to abolish or interfere within any state with the domestic institutions thereof, including that of persons held to labor or service by the laws of said state. Fortunately, for those who are worried about this question, the Civil War intervened, and it became an academic issue, but it's still a worthwhile academic issue for us to consider today. In any case, the majority in the Sri Lanka case upheld the amendment, viewing it as both unthreatening to constitutional identity and consistent with existing constitutional arrangements, the most important one of which was unitary government, which in fact confirmed the authority of the Buddhist majority. They, therefore, saw no need to rely on Indian cases such as Kesavananda and Minerva Mills. The dissenting opinion, however, said, quote, "The 13th Amendment seeks to create an arrangement which is structurally in conflict with the structure of the Constitution and with its provisions, both express and implied. For them, Indian jurisprudence was directly relevant to the task at hand." Now, that the minority assessed the implications stemming from these constitutional changes with more alarm than the majority is less interesting than is the unity of purpose upon which they both predicated their jurisprudential choices. Maintenance of the ethno-republican character of Sri Lankan constitutionalism. All of the arguments made in both opinions about federalism, popular sovereignty, the relevance to Sri Lanka of India's basic structure doctrine were deployed with that predominant end in mind. So what might the Indian proponents of the basic structure doctrine, what might we learn from the uses of the jurisprudence of the neighboring country to India in this regard? Most Indian judges were and are fervent supporters of Nehruvian secularism. As such, they tend to recoil from any move in the direction of an ethnically or religiously defined state. And so they might conclude that not all heritages are so precious as to justify an aggressive and unyielding defense of constitutional identity. Setting aside such speculation, it should nevertheless be clear that resistance to major transformations in a nation's constitutional identity ought not to be viewed as an occasion for reflexive celebration. This, of course, brings to mind, and I can't really address this at length, I'm told, the Israeli case. One can have a serious argument about the merits of what's been called by some ethno-republicanism, but that the immutability of an identity in tension with the precepts of liberal constitutionalism should be held sacrosanct by a judicial tribunal is by no means self-evident. A different lesson, of course, is that the Jewish identity of the state should be placed at the core of an immutable basic structure. I'm not here to argue one way or the other. Similar concerns about preserving identity at the possible cost of a diminution in the prominence of principles of constitutional government have recently been raised in Turkey in relation to this very same question. This is what I want to emphasize, and then I'm going to conclude very quickly. The Indian basic structure doctrine was built against the backdrop of a determined threat to constitutionalism in its generic form. This leaves open the question of its applicability to constitutional amendments that preserve the essentials of a constitution but are transformative with respect only to its specific identity. So, to conclude, a constitutional amendment may be considered problematic in one of two ways. One, the change it portends could subvert the essentials of constitutional government, at the core of which is the rule of law, the administration of impartial justice. Think Indira Gandhi. Second, the change it portends could substantially transform or negate a fundamental political commitment of the constitutional order that had been central to the nation's self-understanding. The second possibility may be considered a variant of the first, but it can also stand separately. Thus, both the American and Sri Lankan 13th Amendments cannot reasonably be interpreted as threats to constitutional government, although in each instance a plausible case can be made that the constitutional changes embodied in the amendments represent a critical departure from what Burke called the prescriptive constitution. As for Burke, who is less reactionary than he is usually taken to be, consider this observation upon which I will conclude. Said Burke, "To say your Constitution is what it has been is no sufficient defense for those who say it is a bad Constitution. Our sympathy for Indian judges whose high regard for the Constitution's secular aspirations has reinforced their determination to redefine the meaning of judicial supremacy is understandable given the nobility of these aspirations. But is continuity the virtue to be exalted when the nobility of defining aspirations is less obvious? In the case of Sri Lanka, for example, where ethnic domination is the feature of constitutional identity most likely to inspire the judicial invalidation of a constitutional amendment. So let us learn finally from an American judge, I might as well conclude with an American, who I think speaks to this issue in an interesting if oblique way. Said Judge Learned Hand, "This much I think I do know, that a society so riven that the spirit of moderation is gone, no court can save. That a society where that spirit flourishes, no court need save. That in a society which evades its responsibility by thrusting upon the courts the nurture of that spirit in the end will perish."
Thank you very much, Professor Jacobsohn. Let me just say, maybe to our students, that the Kesavananda case that Professor Jacobsohn referred to, this Indian landmark case, holds about almost 800 pages. That means twice the length of our land bank decision, the Bank Mizrahi case, meaning that you are very, very lucky to study constitutional law in Israel and not in India. And please take it into your consideration, that you don't have to read Kesavananda. Now, our next speaker is Professor Eivin Smith, who is a professor at the Faculty of Law at the University of Oslo, a member of the Norwegian Academy of Science and Letters. He's published a large number of books and articles on domestic and comparative constitutional law. He has been chair of several governmental and parliamentary inquiry commissions and is the chair of the Norwegian Institute for Social Research and, of course, a member of the Executive Committee and chair of the Roundtable Commission at the International Association of Constitutional Law. It's a pleasure to welcome Professor Smith to speak about an old protected constitution.
Thank you very much. Did you intend to stop the reading just now?
I can go.
No. Just I'm very happy to be here, to take part in this conference, first of all, and to be here in Jerusalem. That be my first remark. The second is, of course, that as someone already predicted earlier today, that I will speak about a completely different experience, which is the old constitution of Norway, adopted back in 1814, actually. And for that reason, even if amended on a number of occasions, now, as it stands, is certainly the second oldest constitution in the world, except, of course, the British unwritten constitution in many ways, after the US Constitution. And let me even recall that, even if not everybody might know it, we certainly have the second oldest system of judicial review working in the world that grew up early in the 19th century, just after the adoption of the Constitution as well. So then we have paved the way to the core issues, of course, of this conference about someone who might feel empowered to uphold constitutional norms, even in the absence of a separate, specialized constitutional court, as in many of the countries we speak about, but certainly not in India and not in Israel, at least for the time being. Now, one particular aspect of this system may deserve more attention, and certainly today, some important scholars like Pernis and Heberle has recalled, has pointed at the so-called supranational clause, supraconstitutional clause of the Norwegian constitution as the very first example of its kind in the history of constitutional law, and an example that has always been hinted at. They're certainly exaggerating, at least in our times. At least it's the first time today I heard it cited. I could not really count upon you knowing what it says, unless, unlike Germany and the US and all that. So I will just briefly read out the relevant part of Article 112 of the Constitution of Norway. Article 112 is the final article of the text dealing with constitutional amendment, most aspects of constitutional amendment. I will not go into the procedural parts of it, but it states as well, and that has been standing exactly as it is still now, since 1814, without any amendment, so to say, if that should have come up as a possibility. It states that such amendment, as referred to earlier in that article, must never, however, contradict the principles embodied in this constitution, but solely relate to modifications of particular provisions which do not alter the spirit of the constitution. And then, of course, normally we boil that down to the expression, the spirit and principles of the constitution. So in other ways, no amendment may be adopted if transgressing this limit. Apparently, this clause was the first adopted ever in the world of this kind. I think that Professor Pertman said that the US was older. I think that is not true, because that provision on the Senate indicates itself how it can be amended, actually, by consent by all the states. But leave that apart. We can take that in the discussion, except and least for this debate. I think that might be so. It's often said like that. It was followed later on, more or less exactly, by countries like Greece and Ecuador, apparently. But later on, then, of course, we have had new generations of supra-constitutional or eternity clauses. Second generation, I would call it, probably started by the French provision about monarchy or the republican form of government back in 1884. Then, of course, Germany after the Second World War, etc., etc. I will not go on in this enumeration. We can see from what I just cited that the text, at least, of Article 112 is very open-ended. Then it makes it for the constitutional culture of the country, and in the last end, perhaps for the constitutional judge of the country to decide what might be to be found in it. This is, of course, it may provide an excellent starting point for extensive interpretation, activist or whatever you call interpretation, that you might find it in some countries, not that much really, but in some countries possibly, or the contrary, and it might be no striking observation from my side to say that in Norway it has rather been a down-to-earth approach to this provision. So far, we have been addressing the overall theme of the roundtable by expressions like supraconstitutional, or first of all, eternity clauses. They are, as has been observed by many, questions about terminology, less than by the part of reality that we call reality, because terminology is part of that scope, of course. I will stick to my main task at this occasion of discussing and making some observations about the Norwegian system, but let me nevertheless have a few remarks on even how to qualify such texts. First of all, it has already been pointed out, the term supraconstitutional is certainly misleading in many ways, at least insofar as no particular amendment procedure has been attached to the particular notion. Otto noted that, of course, this morning, and I completely agree with that. Maybe we should speak rather about higher constitutional law than about supra-constitutional law, due to the fact that there is no, distinction in amendment procedures at this point. Then we have, of course, an example of a self-referring norm. There are many examples of that. Why couldn't we, like Schmidt suggested and many others, of course, just abandon the clause and then go ahead? I will leave that now, just let it be mentioned. Then the second point would be about the expression eternity clauses. Claude Klein mentioned that his professor in Paris in the 50s, I think, laughed when he pointed to this clause about the Republican form of government. He was not the first one to laugh about such clauses. Some of my predecessors did the same in the 19th century in Norway, saying, ha, 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 human beings cannot decide forever. And in a sense, of course, I completely agree with that. But it may very well be that the Founding Fathers really did not intend to establish an eternity clause in that particular sense. It might be much more sensible to read into such a text, at least the Norwegian text and probably some other texts as well, that it is about precisely amendments to the existing constitutions within the limits of the existing constitutions, with no intention of barring the way to new regimes, new constitutions in the future. And if they should want to do that, of course, then we could really start to laugh, but because that is a different issue. So in that sense, it has been suggested that rather than talking about eternity clauses, we should speak about suicide pacts, in the sense, it's not destroying itself, so to say, but it's defining the limits to life, so to say, its own life, saying that if you transgress this and that limit, then Constitution does not more exist, then you have a new one. That's another way of saying more or less the same. Others have suggested similar things during today's debate, but let it be said as well. And even more, we have the idea that in some constitutions at least, you have the explicit even distinction between amendments to the existing constitution and the way to establish a new one. The German example, of course, has been mentioned. It's one of the famous ones. But when they made this constitution during a few weeks in 1814, they regarded a number of other foreign constitutions, including some of the state constitutions of the US, and you find similar examples here and there otherwhere in the world. So this is a perfectly possible way of reading it, but leave it like that. Let it stay as a possible discussion. What is in this particular clause about spirit and principles? And then I think we have to distinguish, at least when it comes to a constitution that exists for 2 centuries, more or less, between the initial spirit and principles. What might be the meaning of that in 1814? What might have been the meaning of that? Not of course the intention, but the meaning. Or second, what might be the sensible meaning of this clause today? If we have a look on the 18 situation, this constituent assembly, elected actually by the people, well, in ways that the Council of Europe nowadays would not accept, but that's a different matter. They started their work by adopting 10 principles, 10 commandments, so to say, of what should be the basis for the continuing efforts to make up the Constitution. That was finally adopted on the 17th of May of the same year. That's some 5 or 6 weeks later. So some would suggest that these 10 principles are the principles, or the spirit, so to say, of the Constitution. But if we have a closer look on these principles, we have to say that some, first of all, the list of 10 principles are rather disparate. Talking about important and much less important things. Some fundamental elements that were in that text did not appear in the final constitution, like the freedom of religion, that appeared much later in the text of the constitution, actually 50 years ago from from now. On the other side, some of the principles found into the text of the Constitution, it should be mentioned here, like the ban on Jews entering the kingdom, was not mentioned. I mean, was taken in even into the text of the Constitution, but was abandoned only some 40 years later, luckily enough, of course. So, I mean, there's a lot to be said about the viability of these 10 principles, and most would agree nowadays that we could not really rely on them. In the aftermath, perhaps it might be more reasonable to suggest that it is all about some limited number of basic principles of the kind we have already seen, like an elected legislator, other things as well, like the existence of a monarchy, separation of powers, at least elements of that, and independent judiciary that was actually mentioned, national sovereignty, of course, a confessional state, which is quite a different matter today, and some elements at least of human rights. They were included, a number of them, in the text of the Constitution, not only in the preamble or somewhere else, as in the US or in France at that time. This ends up with some sort of an open-ended catalogue, so to say, which again opens up for extensive or much more restrictive interpretation. I will just recall what I just said about the choice between the two, and the choice really has not to be made, but that's a different matter. When today, what might the spirit and the principles of our old constitution look like? I mean, then we might easily get into the discussion about the original meaning, or why not the living constitution. At least the last one has been mentioned already during the discussions of this day. But I have to remark that such notions are largely taken from the beginning, not any longer only, but from the beginning, from the US as debate, of course. And for many, many reasons, the US debate seems to be rather irrelevant to many European countries, for instance, for many reasons, including the fact that, unlike the US Constitution, which practically is impossible to amend, I exaggerate a bit, but basically, I mean, most European constitutions can actually be amended, then opening up different ways of regarding, I mean, this original meaning discussion, so to say. And when it comes to the Constitution of Norway, at least it has actually been amended a lot. The basic structure, in a certain sense, not exactly in the Indian sense, but in a certain sense, I mean, of the text, has been kept. But except for that, I mean, 2/3 of the articles have actually been amended on substance at least once. It's nothing like Belgium or Hungary, but still, I mean, there has been a substantive development of the text since then. So even if we had known the initial meaning of this clause quite exactly, the meaning of today could not possibly be established without taking this intermediate discussion into account, for two reasons at least. First, comparing with 1814, we have completely different ideas about a lot of things like the monarchy and the confessional state as compared to that time. If we really stick only to that element, we would really enter into discussion of the original meaning. I will not do that. I don't think it is needed, quite simply because we have all these formal amendments as well. Of course, each of them may be submitted to the spirit and principles test. Some actually have in a certain way, at least. But after some time, if an amendment is adopted, not really tested like that or found okay, then you have a series of amendments on certain critical points of the Constitution, and then we end up with a sum of amendments. So after a century or so, I mean, it would give little meaning to say that the sum of amendments is unconstitutional, so we have to go back to what happened before the amendment series started. In the sense, I mean, the initial original meaning is following, as if it was a living constitution, which is at least through formal amendments. I will just give very shortly one example of what this might mean if you take the monarchy. There are many reasons to discuss whether really that was a part of the original meaning or not. I will not go into that. Let's assume that this was the case. then nevertheless we have to observe that on a number of quite important issues, the text of the Constitution has been amended later on, among other things in the late 19th century by introducing amendments that opened up the way for a gradual change towards parliamentary government. A century ago, they changed the Constitution in order to make the countersigner of the Prime Minister a condition for the validity of royal resolutions, which changes the whole meaning in a sense. And even more, a little bit later, but not much later, a century ago, basically, they ended this same article, no this one, but Article 112 on constitutional amendment, saying in an indirect but very explicit way that the king has no veto, which makes that the other part of the system, so to say, can abolish the king. Some argued at that time that by that amendment there is no more a genuine monarchy in Norway. It may be, that is a way of saying it, but in any case we cannot understand the part of the spirit and principle discussion today without taking all these developments, even by formal amendments, into account. Now we could continue like that on other hot issues like the confessional state. I will not do that. I believe I have not really got the time for doing that. But really, I mean, the idea of a living constitution in this very peculiar sense has to be taken into account by old constitutions like the Norwegian one, submitted to a number of quite important amendments. Maybe each of them did not transgress the spirit and principles limit, but in some, at least, the substance of the spirit and principles has changed. Most of the other constitutions are much more recent. You do not exactly have that problem yet, but that will certainly come, insofar as the regimes are successful and last for a long time. Now, how about this clause in constitutional practice? Just a few main observations. There were often references to this clause in political, including parliamentary debates in the 19th and early 20th century. And very often the remarks were phrased in a way that did not leave any doubt as to the binding character of this clause. That is the first one. After the end of the Second World War, references have become much more sparse, with the exception that Europeans might understand at least about the national sovereignty when it comes to the eternal question, the Flying Dutchman on Norwegian politics, which is Norwegian membership in the European Union. Coming up all the time, then of course national sovereignty again is on the agenda. On the few occasions during the 19th century, the Supreme Court was asked by the Parliament to give I calculated 25 minutes, but okay. We see, on advisory opinions on the compatibility of proposed amendments with the spirit and principles clause, and accepted it on the two occasions. The first, by the way, was about the compatibility of a project to amend the constitution in order to abandon the clause on ban on Jews entering the kingdom back in 1842. So I just mentioned that. The Supreme Court, or any court, so to say, has never had to judge upon this relationship. On one occasion, quite recently, they refused to do it, but then they sheltered a little bit behind the absence of a legal interest to act. So they avoided that question, so to say. Now, more about judicial review, which is, of course, is a core issue in these elements. Let me very, very briefly say that in order for a constitutional amendment to qualify as a constitutional amendment, it should be tested that the procedure is acceptable. So in that sense, more or less by necessity, a court asked to apply a constitutional text as part of positive law has to test the procedure. And most agree that the judiciary in Norway could do that. It has never really happened, mainly because it was never asked like that on the 2 or 3 occasions where it might have been possible to do so, because it was some sort of national consensus about changing the constitution in the way they did. When it comes to the core question about substance, of course, and that is really the question today, the common answer in the doctrinal part of the legal literature is really that no, the judges could not do that. I tend to agree on both points, but I would like to just briefly make 2 supplementary comments. One, why could it be argued that judiciary could not review constitutional amendments? Well, if you take a step back and have a look on judicial review of the constitutionality of legislation, for many reasons, there are good reasons for that, actually. And one of the reasons, I would say, in Europe at least, is that if really the court is completely mistaken in the eyes of the political environment, then the constitution may be changed. Hence, the constitution, the derived constitution-making power got the last word. If we accept that the court has got the last word on what could really be in the constitution, then we take away this element in the checks and balance system, leaving the last word to, excuse me to say so, and elected judges, and I tend to not really believe in that. But that's really my personal idea. Then I might be said to end up in some sort of an unconditional positivism, saying that whatever the parliament as the derived constitutional power might decide should be binding upon us. What could be said to that? Well, actually then I would like to return to elements that some have hinted at during today's discussions, and that is really that we are not only jurists, not even only judges. We are human beings. We got obligations, I think, under moral laws, religious laws, whatever we call it. That depends according to whom we are and where we are living in the world. So in the sense, if really the Constitution is amendment in deeply unacceptable manners, I would prefer to leave my job. You mentioned the same possibility, Barak, and really, I mean, finally, I mean, do really revolt, whatever, I mean, in order to fight this unacceptable political regime. I would like to recall, and that has not been mentioned yet, I mean, an Enlightenment idea about the right to resist oppression. It is explicited, of course, in the 1789 French Declaration. In a different manner, it is explicited in the German Constitution. You find similar in some other constitutions. Then you might argue it is about law. I don't think that is very important to know if it is law or not law. We have finally some obligations that should prevail, even if the Constitution or the constitutional system in the formal sense does not accept that. I was given, and that would be my last remark, I was given the title on a protected constitution. Now, is it really a protected constitution? In the French version, I see it is even strengthened, a well-protected constitution, bien protégé. Is that really true for the constitution of Norway? Well, actually, I have been commenting upon that all along the text in many ways. It has been, to some extent, protective, I would say, at least if we accept that constitutional law is not only about jurisprudence, and I think we agree on that point, at least I hope we agree on that point. By politicians in the 19th century and even later, it has been regarded and binding. Of course, we don't know always if they argued like that because they liked the outcome, because they felt bound. But at least at some occasions, I think that contributed to giving the right outcome of the procedure. Then, of course, I'm speaking on behalf, not on behalf of, but from a Norwegian perspective in this context. And don't forget that Norway had the chance of having a very smooth political development. We kept the constitution for 200 years for different reasons than you, but still we kept it. Some Germans came at all that, but that is really nothing to do, not much to do with the basic stream of development. maybe that is the final answer to the question of being well protected by this clause. We could not say that the main reason why Norway has been lucky enough to have this smooth development is the existence of this clause and the way it has been used in some of the practice. But on the other side, I mean, it's at least a symbol of this rather smooth development. It's mitigated. It's halfway between law and morality, and maybe it's good like that. Thank you very much.
Thank you very much, Eivin, for your contribution and mainly for keeping the time limit so well. Thank you very much. Our last friends and colleagues came all the way from Mexico, and I would like to present them both to take the floor. Dr. Héctor Fix-Fierro, who is the director of the Institute of Legal Research at the National University of Mexico. Dr. Fix-Fierro's main field of research is, of course, constitutional law and legal sociology. He's published a lot, I think over 80 essays on human rights, constitutional and judicial reform, and also for both international and international publications. I present you also Dr. Francisco Tortolero Cervantes, a scholar at the Institute for Legal Research in Mexico. Dr. Tortolero's main field of research is constitutional law as well. He specializes in judicial interpretation, in law and politics, and in comparative constitutional jurisprudence. We're very pleased to have you both all the way from Mexico, and the time it took you to come here is the time it's going to take us to go to Mexico in December. Please.
Yes, thank you very much. Good afternoon. Don't be afraid. We're not going to speak for 50 minutes. We're two, but we are going to speak only for 20, perhaps 25 minutes. Well, let me first start by thanking Professor Claude Klein for the invitation to be here. It's the first opportunity we have to speak in a round table. And of course, it's also a welcome opportunity to give you a glimpse of Mexican constitutional life, since you all are coming down to Mexico in December, so you may have an interest in it. So basically, we want to tell you about a few recent cases of our Supreme Court that have dealt with this question, whether the courts may or may not review the constitutionality of constitutional amendments. So, we'll tell you something about the cases very briefly, say something about the cases. We have been listening very hard to your presentations during the day because we're not very clear what we make about these cases, so we learn from your own reflections. And before going into that, there are three elements of the political and constitutional background and context that you perhaps should know about in order to understand the whole picture. First, we have a process of political liberalization and democratization. I would say after 1977, there's some disagreement as to the moment where this process started, but let's say it started in the late 70s. And the outcome has been that the strong president and the hegemonic political party, the PRI, have almost disappeared, and this has led to a relatively weak presidency with a multi-party system. And second, the political center of gravity has gone from the presidency more or less to the Congress, and within the Congress it's three main parties who are making the important decisions. And this is especially after the year 2000, when the PRI lost the presidency, it had held for 70 years. So this was a big change. Second, well, actually, Mexico has a relatively old constitution, one of the oldest constitutions in the world. It's a constitution of 1917, but this constitution has been amended a lot of times. So in practice, it's not really a rigid constitution. There are some laws in Mexico that have not been amended, but the constitution has been amended almost 500 times since 1917. and almost 2/3 of those changes have been introduced after 1982. So this process of constitutional amendment has a lot to do with the process of democratization and liberalization. And in general terms, those amendments have the aim of reforming the electoral system. There have been several electoral reforms. They have strengthened the legislative and judicial branches of government vis-à-vis the federal executive, and basically they have broadened the scope and the protection of fundamental rights. And the third element is the transformation of the Supreme Court of Justice into what is essentially a constitutional court. This has been done also in several steps, 1987, 1994, 1996, and 1999. Oh, sorry, there's a mistake there. There's a 9 missing. These amendments changed the composition of the Supreme Court. They reduced the number of justices, and then they gave the court additional powers of judicial review. And basically, another mistake, that transformed the court into a more or less a European-style constitutional court, although it still is an ordinary Supreme Court within the judiciary according to the U.S.-American model. And then the court has become increasingly active in the public arena to the extent that the president has diminished his role as an arbitrator of political conflict. This role has been taken over by the Supreme Court, and then the court has had to decide difficult cases like in elsewhere, abortion, electoral reform, many times, telecommunications, the presidential veto of the federal budget, which is not clear in the constitutional text, the discharge of military personnel with HIV, etc. So, sorry, okay. So I let Paco take over.
Well, we're experimenting a format that Claude very kindly proposed to have this dual intervention. So I'm starting speaking about this first relevant case in our constitutional recent history. And we speak about 1982. Héctor just said that in 1982 and so on, since up to maybe last month, there's been like 3/4 of the amendment process in the recent history of Mexico. So the first time an argument concerning an constitutional amendment had to do with something my dear friends in France know very well, which is nationalization of public industries, and it's even almost the same year. Well, that happened that, to make the story short, I'm not going to speak about all this story, why we had a huge economic crisis. We've been in a lot of them, so it's just another one. And in that economic crisis in 1982, due to external debt and the government not being able to pay the service for the debt, so devaluation of currency was not enough, and so we had to pay our obligations upon international banks. And, well, the president didn't have any choice but expropriating private banks. Of course, you can imagine bankers were really upset against the president. For the first time, they were kind of harassed by the president. So this time, the bankers sued through judicial review, arguing for the first time that such a decree, well, maybe a decree is like, could be, let's say, sued through ordinary mechanisms. But afterwards, like 3 weeks before, in order to justify the process of expropriation, the president published a constitutional amendment. So in that way, it was the perfect manner. He could just avoid judiciary review of an ordinary act. Well, that first year, of course, courts didn't have many incentives to control, and they just, let's say, didn't control the act, saying it was just a matter of procedure, that there was no way a constitutional amendment could be against the Constitution. So I pass the microphone to Héctor, maybe to explain the next cases.
Well, in this case, the justices of the Supreme Court were lucky. They didn't have to get involved. They didn't have to confront the president. Those were the times of the strong presidency. The second case is a case that came after an important electoral reform in 1996. And this reform, among other things, provided for the popular election of the mayor of Mexico City. But in a transitory provision of the decree, it was stated that nobody who had previously occupied this post could be a candidate. So this was dedicated to a particular person, which was Manuel Camacho, who was a former mayor of Mexico City. And he went to the courts challenging the amendment. But it was, I would say, a particular problem with his allegations, because on the one hand, he repeated several times, I'm just dealing with the procedural issues. I'm not challenging the substance of the reform, although it is a violation of my political rights. And then it was very difficult to separate both issues. You have to go first to the district judge, the federal district judge. The judge dismissed the complaint as notoriously inadmissible. Then Camacho went to the Supreme Court, and the Supreme Court accepted to take the case. And the court decided by a narrow margin, 6-5, that the district judge had to admit the case again and consider its merits. And then the district judge denied the protection. Camacho went again to the Supreme Court, and in the end, the court dealt with the merits of the case and decided that there was no violation as alleged by Mr. Camacho. Sorry. The third one, Paco?
We had in 2001 another relevant case. Many of you might remember about this revolt, this almost guerrilla in south of Mexico, the Zapatista guerrilla, that came up in 1994. In those years, one of the main demands of those groups were the lack of rights for Indian populations. We have to say, in Mexico, Indians represent like between 13% of the population. We are 107 million Mexicans, or like that. So you can imagine it's like 15 million people. And historically, they didn't have really their rights guaranteed. That happened in 94, and 2 years later, or a year and a half later, all the groups, included the rebels, were part of a big national debate about how the rights should be protected. Let's say several efforts were created, but the constitutional amendment to write down all those agreements was forgotten till the regime changed for the first time. A president coming from a different party, that the PRI, the party who lasted 70 years in power. It was President Fox in year 2000. It's a little bit surprising that the Senate, in the process of reforming the Constitution, the Senate was the one who rather changed much of the contents of that amendment. Because of course there were many technical reasons that the Senate would say that if for instance, the indigenous populations had autonomy, the regime would, which is a federal regime, would have had to be adapted maybe to a fourth level of distribution of powers. So by the end of the day, many of those expectations were not included in the final text of the Constitution. We have to say also that one of the characteristics of Mexican Constitution is very long and very detailed. So the problem is that, of course, once we have a lot of rules, you have a lot of possibilities to be mistaken. So a group of mayors, basically from indigenous regions, sued the court again, and this time this was directly to the Supreme Court. Maybe this was the first time that the court had to be like pronounced directly on a trial that came like through an appropriate procedure, and the reasons, let's say, of course, according to that characteristic I just mentioned of the detail on the text, the arguments from the defense of all this group of municipalities, of Indian municipalities, had a lot to do with substance of the Constitution and not only with the procedure of creating. In that opportunity, the Supreme Court just said once again, but this time did it like through a 8-3 vote, that the type of procedure was not adequate to be like to challenge a constitutional amendment, and let's say this type of trial was not designed to challenge a constitutional amendment. Once again, we can see that this evolution of Mexican political system was announcing once again that the judges were very very careful of not touching like the basic structure, and specifically with let's say to giving all the preference to the will of citizens, but they kind of gave the preference to the will of the legislatures.
Well, if you let me add something, this decision made many people angry. They felt, basically, people coming from the indigenous groups said they felt insulted because the court did not even agree to look at the merits of the case. It just dismissed the case for procedural reasons. Then we have in the year 2007 another important electoral reform, and this reform introduced an absolute prohibition for parties, citizens, and any other organization to buy time in radio and TV stations for the purpose of political and electoral propaganda. This has to do with the presidential election of the year 2006. It's a long story, but basically it was a kind of radical prohibition that made also many people angry, especially those from the radio and TV networks. And then two small parties went to the court. They challenged not only what they claimed to be procedural violation, but also violations to fundamental principles of the Constitution, like electoral fairness, the right to vote, the multi-party system, freedom of association, and especially freedom of expression. Finally, the court, by also a narrow margin, 6-5 vote, in the end by a 7-4 vote, argued that the court's power to review the constitutionality of general laws did not encompass constitutional amendments. So this is a reversal from the previous cases, but this was a different type of proceeding. So this is one of the problems we'll talk about.
And very close to that, to the case, there came another issue to the court, but this time directly from political parties. You have to say that after this weakness process of the presidency, then of course other branches of power intend to take over some of the competencies and influence. And one of the main factors of influence today are political parties in Mexico. Well, what happened in this case is like a private company sued. Let's say there's a special procedure for private persons to sue an amendment, but this time, like a generic amendment, a legal amendment, but this time he argued elements also of let's say, of constitutionality after this reform, like constitutional reform in 2007. So what happened at the end was, for the first time, and this is like a total change after 2 weeks of a very recent decision, that the Supreme Court declared that a court of district court, first instance in the federal level court, could control constitutional amendments, but only the ones that the court would permit, the ones that once, let's say, the case could come to the federal jurisdiction, and that there was an authorization of the Supreme Court to give back the case to the first level judge in order to unapply a constitutional amendment. Of course, there was a lot of reactions in academic because everybody could say that how come a district judge could ever unapply a constitutional regulation. Mm-hmm. So it was also another like sign that the Supreme Court could start like naming herself the organ who was supposed to define the nuances of the Constitution.
Mm. Well, as far as we know, this is the first time a constitutional amendment in Mexico is declared unconstitutional. But this was done by a district judge, and the effects of the decision benefit only the party, the plaintiff. Well, if you are confused after these cases, then let me tell you that we are confused also. And we think that the situation of this issue in Mexico is particularly unclear, and we think this is due to a combination of legal and political factors that at the same time promote this type of cases and at the same time prevent the courts from following consistent line of judicial action. So let me just mention the factors that we find are relevant. We are not going into the relationship between the different factors. First, we have mentioned different types of proceedings, amparo, suits, actions of unconstitutionality, and constitutional controversies. So the outcomes of different types of proceedings have been different. Then the consequences of the decisions are different. In some cases, theoretically, the amendments could be completely annulled. In other cases, the effects are only inter partes. Then the problem of distinguishing between formal and procedural aspects of the substance of the constitutional amendments, the tradition of formalistic interpretation we have in Mexico, the increasingly detailed and extensive character of the constitutional text that was mentioned by Paco, and of course there are also strong disagreement between our colleagues. And then the political factors is that the parties are increasingly dominant in the process of constitutional amendment. There is a trend towards judicialization of political controversies. The court is more or less active, and of course there are also people who are disappointed because of some of these decisions.
Not even 2 minutes.
2 minutes.
Just
make it quick.
Maybe I would like to put another issue in the table. After 2009, there was the decision, for the first time the Supreme Court declared the conformity to Constitution of a state of the Union constitutional amendment, in which the interruption of pregnancy is permitted up to the 12th week. And the interesting topic, and I would like to hear some of your opinions, is after this like declaration of the Supreme Court, 18 out of the 32 states of the Union, they amend their own constitutions in order to declare that life starts on the moment of the conception. So my question would be, if the Supreme Court already declared it was in conformity with the Constitution, isn't that like movement, that political movement of states, unconstitutional? I don't know. This is one of the cases that they are now happening in Mexico, and of course the consequences are not only theoretical, because we have laws that are applied all over the country, general laws in federal terms. So you can imagine if there's a general law about responsibility of medical doctors, well, what about if a medical doctor provokes a problem with the conception of only the product of fertilization? Is he responsible for murder? I mean, it's like we have those kind of questions that many times just a matter of politics mixed up with the constitutional law is really problematic. I'm sorry.
No, it's okay.
Okay, well, just a few words. We have now also our international problem, in the sense that the Inter-American Court of Human Rights has recently said that the domestic courts in all the region have also the obligation to exercise a control of conventionality, that is the consistency between domestic norms with the American Convention on Human Rights. So is it possible that a domestic court in Mexico could disregard the Constitution because it's in violation with the American Convention? And well, so far the challenges to the constitutional amendments have been unsuccessful, because I think part of the reason is they are supported by a particular dominant actor or coalition, and we ask, is this the sovereign, because it's able to make its decision stance? And of course, in theory, the court has said it could reverse a constitutional amendment, but we very much doubt that this would be really possible in political reality. And then the relationship to the international human rights jurisdiction may contribute to make the power of judicial review something that is really embedded in a different dimension than the national legal system. So these are some developments and questions for the future. Thank you very much.
Thank you very much to both of you for this very well coordinated duet. Let me just tell you that you are on the right way from what we see on your constitutional court. I think this trend of judicialization that you talk about, the political process, seems to me as an Israeli a very, very strong déjà vu. So this is part of what all we're having. We have 15 minutes for discussion, meaning that 15 minutes is 10 minutes. We had 15 minutes because I started. So if there anyone would like to comment, I take the notes now. And Martin, 1, perfect. 2, Dr. Reichman.
Before we finish, just I wanted to say that there are countries in the world which make the picture a bit more complicated because of an institution of exceptions to the text of the Constitution, which are enacted through the procedure required for constitutional amendments and can carve out the substance of the Constitution without amending officially the text. And we would have Canada, Sri Lanka, and Finland in that category, maybe others as well. And we get into a situation where there is an inconsistency between the written constitution and the substantive constitution because of the permanent nature of these acts of exception. And Finland resolved it in the total reform of the constitution by inserting a clause, no exception may be in contradiction with the essential contents of the written constitution. But of course that's not a full solution. I just wanted to complete the picture.
You're right, and if I had the time I would say something about it, but I am the last one. Dr. Eichmann, please. Dr. Eichmann is a senior lecturer of constitutional law at the University of Haifa. For those of you who are not acquainted with him, please.
Thank you. Just a quick observation and a question to the panelists. To follow what Professor Jackson said earlier, and maybe what Roberto Tognati also mentioned, couldn't we conceive of unconstitutional constitutional amendment as a form of procedural check by the judiciary? And by that I mean both procedural and substantive procedural in the following sense. Of course, if there is a certain procedure that the derivative constituent assembly has to follow, then the court or any other organ has to check whether that procedure has been met. But what if there is no procedure, stated procedure? Then perhaps it is the role of the court or any other organ that exercises judicial review to pose before that constituent assembly the following option. Either you abolish the entire constitution, or you do not follow it, or this particular amendment is of no value. And that is a procedural stance, in the sense that what you do is you say you have the option, just amend, that is revise, namely abolish, the entire piece of legislation. We're not telling you whether to do it or not to do it. We're just telling you the scope of your amendment is large enough, which means that procedurally speaking, you're in fact abolishing the entire constitution. So in that sense, it is basically a procedure, and the court is just saying, okay, the proper procedure to do is just to abolish the entire constitution. If viewed in that way, I think that it changes somewhat the role of the court in that situation. Thank you.
Thank you. Thank you very much. I don't agree with you, but thank you anyway. Monsieur le Président.
Merci. Je voudrais simplement essayer de répondre à la question posée par nos amis mexicains. Jusqu'où ça peut aller? Et notamment de cette question très intéressante à la fin. Qu'est-ce qui se passe si des États membres d'une fédération adoptent des amendements contraires à la jurisprudence de la Cour constitutionnelle? Parce que ça, c'est tout à fait passionnant. C'est au niveau national la question que nous posions au niveau international, que vous avez signalé, que le juge Garlitsky a signalé. Est-ce qu'il peut y avoir des amendements de constitution nationale contraires à un texte international et sanctionnables par une Cour internationale? Alors, j'ai une réponse empirique, qui est la réponse de toutes les cours suprêmes, et qui est la réponse de la Cour suprême américaine, à ma connaissance. La Constitution, c'est ce que dit la Cour. Et je ne vois pas comment une Cour suprême, une Cour constitutionnelle, qui aurait à statuer sur des amendements de constitution infranationale par rapport à sa jurisprudence, pourrait se contredire. Elle serait bien obligée de dire que le droit fédéral brise le droit local, vous me permettrez de ne pas le dire en allemand, mais c'est là qu'il faudrait le dire, et que le droit fédéral comprend la Constitution telle qu'elle est interprétée par la Cour compétente pour le faire, qu'elle soit suprême ou constitutionnelle, n'a aucune espèce d'importance. La seule limite, nous la connaissons, nos amis d'Israël la connaissent aussi, c'est le self-restraint de la Cour. Jusqu'où peut aller une Cour sans dépasser non pas sa fonction juridictionnelle, mais sa fonction d'équilibre dans le système politique national? Et là, nous savons que la réponse, Ce n'est pas ici que nous la trouverons, mais peut-être un petit peu au Mexique au mois de décembre.
Merci beaucoup. Okay, we have about 4 minutes to answer, meaning that each of you have 1 minute, starting now.
I might take 2.
If you take 2, that means that, all right.
Okay, so just a couple of quick
Professor
points.
Klein looking at me from the door. You know what it means? Come on.
First on the procedural issue, yes, that's an important question. Sometimes disentangling process and substance is very difficult. In the Indira Gandhi case, for example, the obvious substantive problem of what she did is clear. It blends into the procedural once you realize that many of the legislators in the amendment process that culminated in that monstrosity that came before the court were in jail because of Indira Gandhi's previous efforts. On the federalism question, there is a fascinating story, I can't get into it, in India, which actually intersects with a point that Justice Barak was making earlier about the importance of acknowledging implicit restraints, even if we're not prepared judicially to act upon it, just as a basis for establishing the idea, the principles, that there are limits. And once you understand that there are limits, perhaps you don't have to exercise what's necessary to enforce them. But in India, the president has the power to dismiss state governments for their failure to comply with the principles of the Constitution. Such has been done in a very important case called Bomai, in which they invoke the Kesavananda jurisprudence as an example of a non-judicial institution employing the logic and rationale of the unconstitutional amendment process to exercise its constitutional responsibility, which I gather is your point. Once we have an obligation, once we take an oath to support the Constitution, that establishes a multilateral, not a unilateral obligation on the part of all institutions to do so. Finally, one quick point that did not come up. Nobody has really commented on the question of the ease of passing an amendment. The U.S., of course, is intolerant of this whole notion of implied limits. It's understandable. It's so difficult to amend the Constitution that if an amendment somehow is passed, the likelihood is that it will pass constitutional muster anyway. If you pass 80 amendments in 50 years, the chances are that you will blow it a couple of times.
Thank you very much. Eivin, would you like to comment?
Actually, no questions were addressed to me. I have nothing to say, so to say. Could I just then take the opportunity to say that when it comes to, Reshkalitsky and a couple of other interventions, that I see no problem at all in international judges judging a state because they have done something unconventional in their constitutions. That's perfect, and I'm eager to see what will happen with the Swiss case on the minarets, for instance. You don't know and I don't know, but I'm looking forward to that in anyhow. But I really do not understand what we win by insisting on the idea that international law should really equalize constitutional law. Being into the Constitution, quite simply, for many reasons, but one of them is really that might take away important possibilities for development, now enshrined in the possibility of dialogue. That is one argument. I got several others, but it should be said when I got the opportunity. Thank you.
Thank you very much. And Paco?
Et bon, je profite du microphone pour faire une annonce dans la langue diplomatique de l'association et de vous inviter, effectivement, comme ça a été déjà dit ici, pour les congrès mondiaux qui aura lieu à Mexico entre le 6 et le 10 décembre l'année prochaine. Tout est déjà prêt. Cette année, pardon, oui, c'est cette année, en 2010. Je n'arrête de dire l'année prochaine parce que ça a l'air tellement loin. Voilà. Alors, venez nombreux et merci beaucoup, Claude, pour votre accueil.
Thank you. Thank you. Let me say thank you to all the participants of this long panel of this afternoon. It's been fascinating and stimulating comparative approach. Let me thank Professor and Judge Aaron Barak, Denis Baranger, Ian Curry, Lech Garlitsky, Gary Jacobsohn, Eivin Smith, Héctor Fix-Fierro, and Francisco Tortolero.